regretting walking out of
Trigger warning, child injury. The mother's response? Zero remorse. The judge? Absolutely furious. And that sentencing twist at the end? You won't see it coming.
that bathroom even for a second, knowing I wasn't by myself. I now realize even though they can walk, talk, and be themselves, that does not mean they can be left alone. I have since learned from my mistakes and now I'm asking consent.
Your Honor, we believe the pre-sentence investigation is accurate, and we leave it to the court's discretion to fashion a fair and just sentence.
When the court took the plea in this case, I couldn't help but think about those two children. I didn't know the word debridement before. D-E-B-R-I-D-E-M-E-N-T.
Debridement. Surgeons cutting away dead tissue from 1-year-old feet. The judge isn't being dramatic. He's proving this wasn't a hoopsie. This was permanent damage.
And I think that's how you pronounce it. But these 1-year-old twins sustained severe burns to their feet. And debridement means removal of tissue. I'm assuming to remove the damaged tissue based upon what these children went through. And, you know, maybe I'm old school, but our children, and actually that was my job as a parent. And it was awesome, frankly. You're spending time with your children, but you're watching everything they do, because whether you place them in a bathtub or if they're really young in one of those portable type of things that fold out, hold water, but you have to be in constant watch of these children. I mean, you can't walk out of the room. And not only did you walk out of the room, but you walked out of the room for a few minutes. These children had...
Watch the judge argue with himself. Lock her up versus she's only 21. But notice his real focus? Those kids. Not her. Not public opinion. So tell me, punishment or rehabilitation, which wins?
What happened if they slipped? Or you find them face down in the tub? I mean, as a parent, I'm thinking to myself, oh my goodness, how in the world could you do that? And then, not only leaving them alone, but in such hot water, that they had tissue removed from their feet. Now, I understand it was only a couple inches, but it didn't make any sense when you read the pre-sentence report, and it doesn't appear that there was their feet. And the court does take judicial notice of the NA file. We can't speak about it, what's going on with it, but the whole idea is when you are a parent, you have certain responsibilities. You have certain duties you have to follow. And the number one duty and responsibility is to your child, in this case, your children. All I know is when we brought our first child home, and my parents were there, my wife's parents were there, all the aunts and uncles were there, and then all of a sudden, they're all gone. It just came upon us, oh my gosh, this is our responsibility now. And we had to be responsible. Were we perfect? No. Were you perfect in this case? No. But a message has to be sent that you understand that your children are the most important commodity in your life. Above a significant other, above a parent, above a friend, your children are everything. die for your children, essentially. And you can look upon this case in a matter of ways. One, you could say, lock her up, throw away the key, you're a terrible parent. That's one way of looking at it. On the other side, you have a 21-year-old with no prior record.
Here's the twist. 270 days jail, but weekends only for the first 90. Why? So she can do parenting classes during the week. Punishment and forced improvement. Judicial multitasking.
Who some people might say, the court's not saying this, but some people might say, you don't have business being a parent. But you are a parent, and you have to be responsible. And there's another side of it that, look, I'm not experienced. I don't know necessarily how to do this. They don't come with a manual. I did my best and I really screwed up. And there's no doubt about that. This is a tough case for the court because the court has to balance the interest of society, the interest of justice, tailoring a sentence that fits with the facts of the case, that comport with the guideline range in this case as well. And the guideline range on this conviction on a 2-year felony is 0 to 9 months. That's it. And some people are going to say, throw away the book. Others are going to say, wait a second, the parent made a mistake, parent needs to step up, parent needs to move forward, because in one alternative, if I just simply throw away the key and follow the guideline range of 9 months, Mr. Rooney's right. There won't be visitation with those children in the jail. That's an absolute unfit place for the child or children to be visiting their parent. But on the flip side, if the court just says, you know what, no harm, no foul, conviction enters, no jail time or minimal jail time, and then let the NA case address the matter moving forward. And frankly, I don't know what the status is of the NA case at this point. I'm not sure, and I don't want anyone...
That NA file he mentions? That's a whole separate child welfare case. He can't discuss it, but his face says he knows. This story...
You to comment on it, but I know that I will be presiding over that case as well. And the number one concern of this court, and it has been for years and will continue to be, is these children. That's number one. Even on divorce cases, for instance, when parents are arguing and the court has to make a decision regarding custody, it's not based upon, well, we want to do what's best for the parents. It's best for the child's best interest. And that applies here as well. So with that long diatribe, it will be the sentence of this court that you be placed on a term of probation, not for 3 years, but for 5 years. Conditions of probation include the following standard conditions: not to violate the criminal law of any of the government, not to leave the state of Michigan without prior approval of court, notifying the probation agent at least monthly or such times and places the agent may require, or to complete any mental health or other recommended treatment following assessment by a qualified community-based service provider, complete the Thinking Matters program, not to engage in any assaultive, abusive, threatening, or intimidating behavior. Clearly, this was not assaultive, but this was abusive. In hindsight, I'm giving you some credit there. No verbal, written, electronic, or physical contact with anyone else within an MDOC facility, nor the same type of interaction with anyone that's engaged in the behavior that constitutes a violation of any criminal law of any unit of government. You may not use any object as a weapon you cannot own, have under your control, area of control, a weapon of any type. You must not even possess an imitation weapon. You can't be around anyone that possesses those items. You are to contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You are to complete and comply with all written and verbal orders of the agent, submit to a search of your person and property, including but not limited to your home, vehicle, or computer, without the need of a warrant if the agent has reasonable cause you of items that violate the terms and conditions of your probation. Any arrest or police contact, loss of employment, or change of address must be reported to the agent within 24 hours. You are to notify the agent of any service of a personal protection order on you within 24 hours of service. You are to make genuine effort to find and maintain legitimate employment at a minimum of 30 hours per week unless engaged in alternative programs approved by the agent. Crime victims assessment of $130, probation supervision fee of $30 per month regular, $60 electronic. Court cost of $200, payable at the rate of $10, we'll make that $5 a month. Fine of $200, payable at the rate of $5 a month. Court's waiving attorney fees. $68 in state costs will be ordered. The probation office is authorized and empowered under statute to effect your apprehension, detention, and confinement of up to 72 hours on reasonable cause you have items that violate the terms of your probation, or they believe you violated the condition of your probation. If referred, you are successfully complete any PA 511 programming based upon eligibility. Over the next 5 years, you shall perform 40 hours of community service. That community service must be documented, submitted to the probation agent over the course of your probationary term in written form. Finally, guideline range is 0 to 9 months. That means it's not a prison sentence. And the court, though it's been placed upon the court that they are to consider the guidelines. As I've stated before, we've had cases out there in other counties where the guideline range was followed, but it was overturned, despite the fact that it was within guideline range. Guideline range is 270 days in jail. That will be the sentence with credit for 1 day served. However, as it pertains to the 270 days, for the first 90 days of the sentence, you shall serve weekends. You will report to the jail Friday at 6 p.m., be released Monday.
Tailored justice in real time. He acknowledged the horror, recognized her youth, protected the kid's future, and still delivered real punishment. Too lenient or perfectly balanced? You decide.
Morning at 6 a.m., the remaining jail time will be held in advance. Now, you are sentenced to 270. You are to serve the first 90 on the weekends. The reason the court is doing this is because there is a companion NA case, and most services are provided during the week. By doing so, that will give you the opportunity to continue with services to become a better parent, but there's also that negative side of the sting, that is the county jail time. Understand though, if you violate any of the terms and conditions of the probation, you come back before this court and you're found in violation, don't worry about any programs. They'll be just locked up. That's how important this is. I'm considering Mr. Rooney's argument here, and he makes a valid one. It's my duty to inform you of the right to seek leave to appeal. If you're financially able to provide counsel of your own choice, the court will assign counsel for your public expense. Please initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed at the clerk of the court within 42 days.